guys, welcome to TCV Law series. So today in our class we'll be dealing with two landmark judgments. The first one is Diamond versus Chakrabarty's case. So this case is a US case and it is a very important case because only after this case patenting of microorganisms was taken into consideration. The second case which we'll be seeing today is Novartis AG versus Union of India. So this is an Indian case and this case deals with section 3D of the Indian Patent Act and it deals with patenting of pharmaceutical products. So come, let's go see both those cases. So we'll see the case of Diamond versus Chakrabarty. So in this particular case, A.M. Chakrabarty, he was a genetic engineer. He was working for the company General Electric. So he developed a bacterium which had the capacity to break down crude oil. So ships and all goes in oceans, so they spill, oil spills and all takes place. So this particular bacterium had the ability to treat all these oil spills by breaking down crude oil. So it had the ability to treat oil spills. So the General Electric filed a patent application for the bacterium in the US Patent Office. So this is a US case, not an Indian case. So they are filing patent in the US Patent Office saying Anand Mohan Chakrabarty is the inventor. So when they filed the patent application, that particular patent application was rejected by the patent examiner saying that living things are not patentable under Title 35 USC Section 101. So according to this, living things are not patentable. So what does this Title 35 USC Section 101 says? Whoever invents or discovers any new and useful process, machine, manufacture or composition of matter or any new and useful improvement thereof may obtain a patent thereof subject to the conditions and requirements of this title. So that is what is mentioned in this particular section. So you have to keep in mind that their particular patent act, this particular section says whoever invents or discovers any new. So this is where the difference between US Patent Act and our Patent Act comes up. Because in Indian Patent Act, it clearly says that mere discovery cannot be granted patent. Whereas when it comes to US, they clearly say that whoever invents or discovers anything new will also get patent. But here, the patent examiner is rejecting solely because they are considering microorganisms to be living organisms. So it is living thing, therefore patent cannot be granted. But Anand Mohan Chakrabarty, so since he invented it, he says that the genetic engineering which he performed on that bacterium was a form of manufacture and therefore patentable. So he is telling that there is some change which he did. He manufactured a new bacteria. It is not something which is already there. So the engineering which he did was a form of manufacture. Therefore, it is capable of getting patent. So stating that he is filing an appeal before the Patent Office Board of Appeals. So Patent Office Board of Appeals affirmed the decision of the patent examiner. So then and again appeal was filed before the US Court of Customs and Patent Appeals. So this US Court of Customs and Patent Appeals, they overturned the previous decisions by saying that microorganisms is not naturally occurring and therefore it is patentable. So this is where the major change took up. So this particular court said microorganisms can be patentable. So when this particular judgment was given, the then Commissioner of Patents and Trademarks, that is Sidney A. Diamond, he filed a writ petition before the Supreme Court. So Supreme Court also upheld the decision of the US Court of Customs and Patent Appeals. Moreover, the Supreme Court asserted the principle that anything under the sun that is made by man is patentable. So saying this, the court held that the patentee, that is Anand Mohan Chakrabarty, he produced a new bacterium with different characteristics from any found in the nature and having significant utility, and therefore it is patentable. So basically, Anand Mohan Chakrabarty's bacterium had fulfilled all the necessary criteria which was required for the grant of patent, that is novelty, utility and non-obviousness. Therefore, he got patent over this bacterium. The next case is Novartis AG versus Union of India. So Novartis is a world's leading pharmaceutical company. So this particular company filed an application for grant of patent to an anti-cancer drug in the year 1998. So anti-cancer means it is used to treat tumors and all. So this particular drug's name was called as Gleevec. So what exactly is Gleevec? It was nothing but a beta crystalline form of the original drug. So original drug's name is imatinib mesylate. So its different form, that is the beta crystalline form, is called Gleevec. So they applied patent for this new form. So in the year 1998, when they applied, India did not have the provision to grant patent to pharmaceutical products or agrochemical products that time. So the application filed by Novartis directly went as mailbox application, such that grant of patent would be considered later. So what exactly is meant by mailbox applications? If any company applies for patent for a particular product for which patent cannot be granted under the Indian Patent Act, then that particular patent application will be kept in the mailbox. So that is what is meant by mailbox applications. In the year 2005, when India had to make changes in the Indian Patent Acts in order to be in compliance with the TRIPS agreement, it was made in such a way that India had the capacity to grant patents to pharmaceutical products. So in the year 2005, the Novartis patent application was taken out of this mailbox and taken into consideration. So in the year 2006, the Madras Patent Office rejected the patent application of Novartis for the medicine Gleevec, saying that it did not exhibit any major changes in therapeutic effectiveness over its pre-existing form, that is imatinib mesylate. So this decision of the Madras Patent Office was based on Section 3D of the Indian Patents Act, which talks about enhanced efficacy. So since this Gleevec did not show enhanced efficacy, we cannot grant patent. That's what Madras Patent Office is telling. Two writ petitions were filed by Novartis before the Madras High Court. The first was an appeal against the order of the Madras Patent Office rejecting the patent request, and the second was that Section 3D of the Indian Patent Act is not in compliance with TRIPS and that it is vague and arbitrary and violative of Article 14 of the Constitution. So what Madras High Court held is that it said it didn't have any jurisdiction to decide whether domestic law is in contrary to international treaty. And when it comes to the question of vague and arbitrary, Section 3D's objective itself was to prevent evergreening of patents. So it cannot be considered to be vague and arbitrary. So what is meant by evergreening? So sometimes whoever owns patent over a particular product, he will make minute changes to it before the expiry of the period of 20 years and will again apply for patent such that their product won't fall into the public domain. So what happens is that since it's not falling into the public domain, again and again he will be the patent owner of that particular product. So in order to prevent that evergreening, only Section 3D was formed. So we cannot say it is vague and arbitrary. So again, what happens is that the Novartis is filing an appeal before the Intellectual Property Appellate Board. So it is the appellate body of the patent controller. So when this appeal is filed, the Intellectual Property Appellate Board, they are saying that yes, the beta crystalline form of imatinib mesylate what they found, that is Glivec, it is new and it is having inventive step. But still, what they said is that we cannot grant patent to Glivec because it is hit by section 3D of the Indian Patent Act. So since section 3D is coming into picture, we cannot grant patent to your particular product. So again, Novartis is not getting patent. So then Novartis files a special leave petition before the Supreme Court. Now what Supreme Court says is that when it comes to medicines, efficacy means therapeutic efficacy. And the next thing what they said was the true intention to enact section 3D was to prevent the concept of evergreening, and thus if the invention does not fulfill the test of section 3D, it cannot be granted patent. So they are rejecting the patent application of Novartis, saying it is not fulfilling section 3D. So we cannot grant patent to this particular product. So hope you guys are clear with both these cases. So if you guys have any doubt, please do mention in the comments. Okay guys, so today in our class we saw 2 landmark cases. So by this we come to the end of chapter 2 of the Indian Patent Act. So from my next class I'll be dealing with chapter 3. So if you guys like my class, then please do like and subscribe to my channel. Thank you.